Hello and welcome back. We are going to be talking today about disability laws. We'll focus first on the Rehabilitation Act, the Americans with Disabilities Act, and then also to some limited extent the workers' compensation laws as they relate to the ADA. Let's start first with the Rehabilitation Act of 1973. And I've asked you before, and I'll continue to ask during our discussions, think about what's taking place in our society when these major acts were put into place. So what's taking place in the early 1970s? Well, the veterans were returning from the Vietnam War. And in that framework, there's issues with respect to a focus on disabilities and the focus of needs of individuals in the federal government that have disabilities. So the Rehabilitation Act of 1973 was the first legislative enactment to provide fair treatment for individuals with disabilities. Individuals with physical and cognitive disabilities are covered under the Act. The Rehabilitation Act has been twice amended since 1973, once in 1993 and again in 1998. We're going to be examining three sections in particular of the Rehabilitation Act. Section 501. It prohibits discrimination on the basis of disability in federal employment and requires federal agencies to establish affirmative action plans, we've talked about those before, for the hiring, placement, and advancement of people with disabilities in federal employment. The Act requires an employer to develop and implement affirmative action plans on behalf of handicapped employees. The EEOC is now responsible for enforcement of Section 501 of the Rehabilitation Act. The Act proves to be the model for Title I of the Americans with Disabilities Act of 1990, which prohibits employment discrimination on the basis of disability by private employers. So the Rehabilitation Act was the precursor, if you will, to what later became the Americans with Disabilities Act of 1990. Let's take a look at Section 503 of the Rehabilitation Act. 503 of the Rehabilitation Act of 1973 requires all contractors having federal contracts in excess of $2,500 to take affirmative action to employ the handicapped. Enforcement of Section 503 is carried out by the Department of Labor's Office of Federal Contract Compliance Programs, not the EEOC. So note the distinction with regard to the enforcement aspects. Section 504 of the Rehabilitation Act is a civil rights law. It was the first civil rights legislation in the United States that protects individuals with disabilities based on their disability status. Covered employers include those which received federal financial assistance. The Act was intended to prevent intentional and unintentional discrimination based on a person's disability. Section 504 states that no otherwise qualified individual with a disability in the United States shall, solely by reason for his or her disability, be excluded from participating in, be denied the benefits, or be subjected to discrimination under any program or activity receiving federal financial assistance. Programs receiving taxpayer dollars are prohibited from discriminating against those individuals with disabilities based on their disability status. Now that means that all government agencies, those which are federally funded projects, even including schools, state colleges, universities, and vocational training schools are covered under Section 504 of the Act. Section 504 of the Act deals with discrimination in broader terms than the affirmative action requirements of Section 503. Let's look at that. Some schools and government departments and agencies are the typical sources of entities affected by 504. It is important to note that the Act reaches private organizations as well. So here's where there's a more broad application, such as corporations, partnerships, and other entities receiving taxpayer-funded dollars. Enforcement of Section 504 rests with each federal agency providing federal assistance. This means that the Department of Education, for example, or the Department of Housing and Urban Development, HUD, would provide for the enforcement of Section 504 as related to their respective agencies and covered protections. Note the difference again between the enforcement aspects with regard to these particular sections of the Rehabilitation Act. It makes a difference. The Attorney General of the United States has a responsibility for the coordination of the enforcement efforts of all the agencies. A private right of action for compensatory damages exists under Section 504. That means that individuals can sue in federal courts for alleged violations of Section 504. Title VII remedies and damages are available provided that administrative prerequisites and remedies have first been exhausted. Let's look at some of the more detailed features of Section 504. And we'll see how these features are carried over into the Americans with Disabilities Act. Section 504 protects qualified individuals with disabilities. 1. Under this law, individuals with disabilities are defined as persons with a physical or mental impairment which substantially limits one or more major life activities. Each of those terms have legal impact, which we'll discuss in much more detail in a short while. 2, people who have a history or record of such impairment. And 3, people who are regarded as having a physical or mental impairment that substantially limits one or more major life activities. Each of these 3 features must be carefully considered, and they'll be carried over into the Americans with Disabilities Act analysis as well. Let's look at the term qualified individuals. Qualified individuals with disabilities are persons who meet normal and essential eligibility requirements. Major life activities include, for example, oneself walking, seeing, hearing, speaking, working, performing manual tasks. Qualified individuals with disabilities are persons who, with reasonable accommodation, can perform the essential functions of the job. Now we'll note that term later on as well. Essential functions, meaning the core aspects of the job. The aspects of the job which are material, which are fundamental to the position. Reasonable accommodation means an employer is required to take reasonable steps to accommodate one's disability unless it would cause the employer undue hardship. What are the key terms? Reasonable accommodation, undue hardship, essential functions, major life activities. All of those factors will have a carryover application to the Americans with Disabilities Law. But They originated here with the Rehabilitation Act and its regulatory impact. Let's look at a Supreme Court case in 1987, very important case regarding the Rehabilitation Act. Jean Arline, and these are the facts, could no longer teach elementary school because she had tuberculosis, which of course is a contagious disease, highly contagious. She was first hospitalized for tuberculosis back in 1957. The disease went into remission the next 20 years. But in 1977 and during times in 1978, she suffered relapses. Now we're looking at different years here, 1957, 1977, 1978, but note that the Supreme Court decision occurred in 1987. It might give you some understanding as to how the length of litigation, time-wise, may impact some of these case outcomes. And the fact that litigation can be very time-consuming. We'll talk about other cases in the course where I'll point out specifically the length of time in which the litigation has taken before an ultimate outcome is reached. Back to the Arline case. The superintendent of schools in Nassau County, Florida, dismissed her after it became aware that her illness was recurrent. So it should be after it became aware that her illness was recurrent. Arline filed a federal lawsuit claiming that the school board violated Section 504 of the Rehabilitation Act. The school board acknowledged that she was dismissed because of her condition. That's not contested, but contended that a contagious disease like tuberculosis did not qualify her as handicapped. The district court ruled that Section 504 did not define contagious diseases as handicaps. The United States Court of Appeals for the 11th Circuit reversed, finding that Arline was otherwise qualified to teach, but for her illness, and ruled that she was qualified for handicapped benefits. The Supreme Court, in its analysis, relied on the qualification criteria for handicap status by examining the regulations promulgated by the Department of Health and Human Resources. Now, that's an example of a federal agency. The department made it clear that the act covered illnesses that cause a record of impairment upon an individual's major life activities. The Supreme Court found that both the contagious effects of a disease and the disease's physical effects can impair one's ability to work. The court noted that Section 504, not Section 505, but Section 504, that's a typo, was designed with the objective of protecting handicapped individuals from deprivations based on prejudice, stereotypes, or unfounded fear, while giving appropriate weight to such legitimate concerns of grantees of federal funds as avoiding exposing others to significant health and safety risks. It's important to consider the following criteria set forth by the Supreme Court. And let's look at this carefully. The otherwise qualified provision under Section 504 requires a court to conduct an individualized inquiry, and make appropriate findings of fact based on reasonable medical judgments given the state of medical knowledge about A, the nature of the risk, B, the duration of the risk, C, the severity of the risk, and D, the probabilities the disease will be transmitted and will cause varying degrees of harm. In making such finding, courts should defer to the reasonable medical judgments of medical health officials. Courts must then determine, in view of such findings, whether any reasonable accommodation can be made by the employer under established standards for that inquiry. And what's the inquiry? An individualized assessment, an individualized inquiry. The Arline case was remanded back to the district court from the United States Supreme Court to determine whether she was otherwise qualified for the position. The district court failed to make the appropriate findings to assess whether she was otherwise qualified for the job of elementary school teacher. Let's turn next to the Americans with Disabilities Act of 1990. That's the ADA, and that act was amended 18 years later, and it's known as the ADA Amendments Act of 2008, the ADAA, which was effective January 1 of 2009. So let's examine first, what is the Americans with Disabilities Act? What is the ADA? The ADA was enacted to prevent discrimination against individuals who have physical or mental impairments. It dictates that no covered entity, who's the covered entity? Well, that would be the employer, for example, shall discriminate against a qualified individual with a disability on the basis of the disability with respect to job application, procedures, the hiring, advancement, or discharge of employees, employee compensation, job training, and other terms and conditions of employment. Well, we've heard all of those factors, have we not? In fact, we've studied those factors with respect to other federal anti-discrimination laws. I think by now you're probably seeing the themes and how the threads of all these laws are woven together to really show that there is a bigger picture here, so to speak, that is very uniform and consistent with respect to Congress's desire to protect individuals, advance their rights, and recognize the obligations of covered entities such as employers regarding these laws. Who is an employer under the ADA? Well, that's a good question. Pursuant to the ADA, an employer is defined as a person or entity engaged in an industry affecting commerce that has 15 or more employees for each working business day in each of 20 or more calendar weeks in the current or preceding calendar year of any agent of such person or entity. Well, again, I think you're seeing the common themes that are woven together with respect to these laws, and the common aspects of who is an employer and what the criteria that makes up that recognition. Who is eligible for protection? In order for an individual to have protection under the ADA, the employee must be a qualified individual with a disability who can perform the essential functions of his or her position or desired position with or without an accommodation. Again, note how the conditions, I should say the criteria, are carried over from the Rehabilitation Act into the coverage for the ADA. What does qualified mean? And this is from the ADA. Qualified means that an individual has the requisite skills, experience, education, training, and abilities to perform their job. It also means the individual is capable of attending work. An individual is not qualified if he or she poses a direct threat to the safety of health of himself, herself, or others. to the safety or health of himself, herself, or others. So there's a direct threat analysis with regard to safety or health that's carried over into the definition of qualified. What is a disability? Good question. The definition of disability shall be construed, that's interpreted in favor of a broad coverage under the ADA to the maximum extent possible under the Act. Disability is defined as 1. A physical or mental impairment that substantially limits one or more of the major life activities of an individual. 2. A record of having such an impairment, or 3. Being regarded as having such an impairment. That same criteria from the Rehabilitation Act is carried over to the ADA. Let's look at the ADAA. 3 A's, ADAA. It was enacted September 25th, 2008, became effective January 1 of 2009. Congress made it less difficult for an individual seeking protection under the ADA to establish that he or she has a disability within the meaning of the law. Congress overturned several Supreme Court decisions that Congress believed had interpreted the definition of disability too narrowly, resulting in a denial of protection for many individuals with impairments such as cancer, diabetes, and epilepsy. The ADAA is a good example of how our legal system works. Our legislature can make new laws that, in effect, overturn Supreme Court decisions. We've seen other examples of that occurring in our study of employment law so far in this course. The ADAA states the definition of disability should be interpreted in favor of a broad coverage of individuals. It's much more expansive than the initial ADA was. Substantially limits under the ADAA requires a lower degree of functional limitations than the standard previously applied by the courts. Now, an impairment does not need to prevent or severely or significantly restrict a major life activity to be considered substantially limiting. Nevertheless, not every impairment will constitute a disability. Let's look at this term, impairment. The determination of whether an impairment substantially limits a major life activity requires an individualized assessment. An individualized assessment. Where have we heard that before? Well, we learned of that with the ruling in the Arline case by the United States Supreme Court. This was required even prior to the ADAA. In fact, it was a key component of the ADA of 1990. The determination of whether an impairment substantially limits a major life activity shall be made without regard to the ameliorative effects of mitigating measures such as medication or hearing aids. An impairment that is episodic or in remission may still qualify as a disability if it substantially limits a major life activity when active. Being regarded as, the regarded as section of the ADA. An individual can fall within the definition of regarded as whether the individual has an actual or perceived impairment, and regardless of whether the impairment limits or is perceived to limit a major life activity. Now note this, conditions which are transitory or minor, which as an example would be someone who has a broken leg. That broken leg is going to heal. It's not going to traditionally be a condition which is disabling. So an actual or expected duration of 6 months or less is usually going to be considered as transitory or minor, and it will not fall within the regarded as prong. So a disability is a condition which is disabling. It's permanent or can be permanent. A condition which is transitory or minor will not qualify as a disability. For the regarded as part of the definition of disability under the ADAAA, the focus for establishing coverage is how a person has been treated differently because of a physical or mental impairment, which of course is not transitory or minor. Rather than not what an employer may have actually believed the nature of the person's impairment was or was not. It's how they were treated differently because of a physical or mental impairment, having been regarded as. Let's look at the term major life activities. Major life activities include, but are not limited to, caring for oneself, performing manual tasks, seeing, hearing, eating, sleeping, walking, standing, lifting, bending, speaking, breathing. Breathing, yes, it's a major life activity. Learning, my favorite topic, is a major life activity. Reading, concentrating, thinking, well, that's another good major life activity. Communicating, working, and major bodily functions, functions of the immune system, normal cell growth, digestive, bowel, bladder, neurological, brain, respiratory, circulatory, endocrine, and reproductive functions all fall within this very broad category of major life activities. I think you may be forming a picture in your mind. Anything literally associated with one's living is a major life activity. Let's look at the term reasonable accommodation. It's one of the bedrock principles of the Americans with Disabilities Act. An accommodation request begins when an employee puts the employer on notice that a medical or psychological condition exists which requires a change in the way a job is performed. The employee does not have to specifically request a so-called accommodation. Those magic words are not going to be required, although it's good evidence if they are, and it's even better evidence if the request is submitted in writing. The employer and the employee must engage in communication such that the employer knows why the condition necessitates the accommodation requested. The employer may request reasonable documentation to substantiate that the condition is indeed disabling. A reasonable accommodation may include making facilities accessible and usable by individuals with disabilities. It may also include job restructuring, part-time or modified work schedules, reassignment to a vacant position. Now, there's no obligation from the employer as a reasonable accommodation to create a position under the ADA. But if a position is vacant and open, and the individual possesses the qualifications to occupy that position, a reassignment to such vacant position may be a good example of an accommodation that's reasonable. Other examples would be acquisition or modification of equipment or devices, modification of examinations, training materials or policies, having qualified readers or interpreters assist. Leaves of absence may in some instances be a reasonable accommodation. Relocation of minor tasks. Adjustment of arrival and departure times, for example, may be reasonable accommodations. What is reasonable has to be balanced against a term called undue hardship. And the context in which reasonable accommodation and undue hardship are measured must be closely considered and examined. There's an interactive process which is required. The employer is required to engage in that so-called interactive process with the employee to determine what accommodation will work for both parties. Both parties are obligated to engage in some level of communication aimed at achieving what can be an accommodatable arrangement that does not pose an undue hardship upon the employer. Although an accommodation required by the employer must be effective, it does not have to be specified. It does not have to be the specified accommodation requested by the employee. So in other words, there could be some variance between what the employer is willing and can provide as an accommodation versus exactly what the accommodation specified by the employee is. There may be a balance struck through this so-called interactive process between what is accommodatable and what could be considered an undue hardship by the employer. The employer must grant an accommodation unless it can show that the accommodation would result in an undue hardship for the employer. Let's look at this term undue hardship in much more detail. An undue hardship is an action which would require significant expense or difficulty when taking into consideration or account the factors below. And these are various factors which are considered. 1. The nature and cost of the accommodation requested. 2. Overall financial resources of the facility involved in providing the accommodation. Larger employers may have the means that smaller sized employers may not have to accommodate what is reasonable for the employee and what is oftentimes necessary for them to perform the essential functions of the job. And remember, the accommodation must be made so it allows the individual to perform the essential functions of the job. The number of people employed at the facility can also be considered as an aspect of what is an undue hardship. The effect on expenses and resources can be measured as well. The impact of the accommodation on the facility is a factor to consider. The number, type, and location of the facility can also be considered. The type of operation of the entity, including the composition, structure, and function of the workforce of such entity, can be all considered in evaluating what may pose an undue hardship upon the employer when confronted with the request for reasonable accommodation. Now, this is an important side note here. I've included this in the slide here. And that's employees who are covered under the ADA under only the regarded as theory are not entitled to a reasonable accommodation. So if the employer regards them as having a disability, it makes sense that those individuals, if they're regarded as by the employer, will not be entitled to a reasonable accommodation. Now keep in mind that this regarded as aspect literally is available to the employee even if the employee is not presently affected by a disabling condition, or if the individual does not have a history of having been affected by such disabling condition. So the regarded as aspect is where the employer treats someone differently because they are regarded as having a disability when in fact they may not. And it makes sense then that if they may not have that disability, then no reasonable accommodations are due. I want you to look at the case in the textbook. And Professor Twomey has selected various cases for our study that originate from Illinois courts. And I've tried to point them out throughout in this course, and there will be more that we'll encounter as we move along in this class. But the case of Horgan versus Simmons is a case that I want to draw to your attention in more detail. It's a case that I've also included as a handout, so to speak, in your course materials. It's a case that originated here in the Northern District of Illinois, that's in Chicago. And it is as follows in terms of the facts. The manager of a uniform rental company whose employment had been terminated after he disclosed to the company president his HIV status had been terminated. The employee, Horgan, filed a lawsuit against the former employer alleging unlawful termination and impermissible medical inquiry as to his disability in violation of the Americans with Disabilities Act. So if you haven't read in detail that case, and that's a good case to read in terms of just how these cases are also reported in these materials that we see in our textbook. For example, what we find in our textbook are synopses. They're condensed versions of what would be an actual reported case in the format that you see in your handout for the Horgan decision. This was a case that was brought on the defendant's motion to dismiss for failure to state a claim. A motion to dismiss procedurally is different from a motion for summary judgment. Now let me explain the distinction. A motion to dismiss can be brought by the defendant to eliminate the need for discovery to take place. Discovery would be depositions, fact-finding efforts such as exchange of documents and resources to substantiate a claim or prepare for the defense against the claim. The court is asked to address the legal merits at the outset of whether a claim is even available. And that's what happened here. A motion for summary judgment will occur traditionally after all of the evidence has been determined through the course of discovery. And after the discovery is concluded, if there's no material issue of fact, a court can, upon motion by either party, rule that the case does not deserve a adjudication by a jury and can be dismissed at that later time. It's a later form of a dismissal as opposed to an earlier one for failure to state a claim that the motion to dismiss presents. So the Horgan versus Simmons case is one that was brought at this early stage in the litigation. The court ruled that even if the terminated manager's HIV positive status did not substantially limit a major life activity as required to assert an ADA claim against the employer, allegations in the manager's complaint that the employer regarded him, there you go with that regarded as standard, having an impairment were sufficient to plausibly suggest he was terminated because of his HIV positive status in violation of the ADA. I want to point out another aspect to the ADA that some of you may know or have considered in your studies already, but the ADA prohibits discrimination based on relationship or association. Now, what that means is that the individual himself or herself may not have a disability, but if one has a relationship or an association with an individual who does have a disability, the ADA may reach that employment setting. The ADA prohibits discrimination based on one's relationship or association with individuals who have disabilities. A person, for example, who has a disabled spouse should not be discriminated against because of unfounded assumptions or stereotypes. I want to bring to your attention the case of Magnus versus St. Mark United Methodist Church. It was decided by the Seventh Circuit in 2012. I've included the case site if any of you want to examine that in more detail. But the plaintiff, who was a church secretary, refused to work weekends because her disabled daughter came home from an assisted care facility on weekends. And the plaintiff needed to stay home to care for her daughter. Magnus, the plaintiff, came to work 1 hour late. That was a fact that was not contested. After calling in because of her daughter's condition, and said that she would make up the hour the following day. The defendant employer fired Magnus the following day after she arrived late to work. She sued for associational discrimination in violation of the ADA. The Seventh Circuit Court of Appeals upheld the dismissal of Magnus's claims at the trial court. Now, the trial court, we know, is the district court in the federal court system. In the state court system, the trial court is the circuit court. The Seventh Circuit noted that associational discrimination claims are unlike those otherwise falling under the ADA because employers are not required to provide reasonable accommodations to non-disabled workers. Thus, an employee who cannot meet the attendance requirements of her job, as in the situation with Magnus, is not protected under the ADA. The Seventh Circuit further commented that although an employer does not have to accommodate an employee because of her association with a disabled person, the employer cannot terminate the employee for unfounded assumptions based upon the need to care for a disabled person. Termination based on assumptions regarding future absences relating to a relative's care may give rise to liability, but termination resulting from an employee's past absences do not. Note the distinction. Assume, for example, that an applicant applies for a job and discloses to the employer that his or her spouse has a disability. The employer believes the applicant is qualified for the job. The employer, however, assuming without foundation that the applicant will have to miss work or frequently leave early or both in order to care for his or her spouse, chooses not to hire the individual for such reasons. That's a failure to hire claim in violation of the ADA. These anti-discrimination laws, as we have already encountered, apply to the entire spectrum of an employment relationship, both even before the relationship begins in the hiring stage and even after the relationship ends upon separation or termination. These laws apply. Later in the course, we're going to be focusing on failure to hire claims, and we'll be looking at some prohibited questions regarding what not to ask an employee during an interview. I think you'll find that section of the course very interesting. We'll give some examples that are true life examples that are raised in court actions and the EEOC regulations as well. We'll learn about what not to ask in an employment interview at the last part of the course, which you may think is rather backward and should have been addressed at the very outset of the course. My opinion is that we should first learn what the laws provide and understand the laws in their application so that they can be examined in the entire context of the employment relationship, both before, during, and after. And I think we'll be better prepared to understand the pre-hiring aspects of discriminatory treatment at the end after we've studied the other in between. Let's look at ADA rights and remedies. A timely charge must be filed with the EEOC within 180 days, and that's in some jurisdictions, or 300 days in others, such as in Illinois. Illinois allows for the 300-day time frame because we have a state human rights agency, and the term for that is a deferral state jurisdiction. States which do not have a respective state human rights agency are going to be subject to the 180-day time frame that the EEOC imposes to confer the jurisdiction. Traditional legal and equitable relief is available for violations similar to Title VII. And those remedies, as we've already studied, include instatement. That's if there's a failure to hire. One can sue to get hired, which is instatement. Reinstatement, that's if one's been fired and the court orders that individual to be reinstated, to be made whole, to be put back in a position that they should have occupied but for the alleged wrongful action. Back pay, front pay, compensatory and punitive damages. Now note with the ADA that the same caps on damages applicable to Title VII also apply to remedies under the ADA. And of course, attorney's fees, cost, expert witness fees, all of the traditional make-whole relief, including judgment interest and prejudgment interest, will all be available to the successful ADA plaintiff should the case resolve favorably on the side of the employee. Finally, let's turn to the Workers' Compensation Act. And the focus will be workers' compensation as it's related to the ADA. We're not going to spend much time talking about workers' compensation generally. We've talked about workers' compensation issues already with respect to retaliation aspects. If an individual, for instance, gets hurt on the job and files a workers' comp injury claim and is fired, well, that's a violation of public policy. It's also a violation of the Workers' Compensation Act itself as retaliatory or retaliation. Workers' compensation is required in Illinois, as it is in most states, if an employee is injured while working, regardless of one's fault. The employer is responsible for injuries and the resulting loss. Now that means that one could actually be the source of their own harm, their own injury, but if the injury occurs while working, then there are statutory coverage basis for the remedies that are allowed by law. It's important to also note that workers' compensation laws are statutory, meaning that they arise from the legislature and they're not based on common law judicial development. In exchange for compensation under workers' compensation statutes, employees forfeit their right to sue their employers in common law courts, except for intentional torts. We're going to have a section in this course where we study intentional torts, such as battery, assault, wrongful imprisonment, intentional infliction of emotional distress, and we'll talk about how some of those common law intentional tort claims, as they relate to the workplace, can still nevertheless be pursued and allowed to proceed to court and in front of a jury despite the workers' compensation application. We'll talk about that in more detail, and that will really be the exception to the general rule. And we've talked throughout this course so far, and you've heard me say this before, that we're looking at general rules, and always there will be some form somewhere of an exception which is applicable. So we have to know the general rules, but we certainly have to be aware of the exceptions to those rules as well. In Illinois, workers' compensation claims are adjudicated in the Industrial Commission, not in court. Individuals who have claims under the ADA are not precluded, they're not prevented from asserting their rights based on the exclusive remedy provisions within workers' compensation laws. Now let's think about that carefully. If an employer fails to make a reasonable accommodation for a disability that is caused as a result of a work injury, that's where workers' compensation comes into play, but the employee may still pursue an ADA claim, if applicable, by filing a charge with the EEOC. So, there can be significant overlap between workers' compensation law and the Americans with Disabilities law. Next week we'll be talking about the Family and Medical Leave Act, and we'll see where there's even more of an overlap between the ADA in some instances and workers' compensation acts in others. I want to turn to an important feature regarding workers' compensation and the ADA. And I've labeled this as return to work status 100%. I put 100% into the quotation marks on your slide video here. The ADA requires reasonable accommodations to allow the employee to perform the essential functions of the job. That's the law. You should have that well understood by now. Such accommodations must be evaluated against undue hardship. In the absence of undue hardship, an employee who has been injured at work and is released to return with certain working restrictions cannot be outright refused to return. Prior to the ADA, employers typically had policies of requiring employees to be incapable of performing it should be capable. So, no, I think it's correct here. Had policies of requiring employees should be capable, of performing 100% of the position functions in order to return to work. In other words, if they were incapable, sorry for the misstatement, if they were incapable of performing at a 100% level, then they're not allowed to return to work. The 100% requirement violates the ADA. Let me repeat that. An employer that mandates that an employee be able to perform 100% of their job functions, that's going to be a per se violation of the ADA. Reasonable accommodation analysis must be considered. When it's considered, then that 100% essential function requirement rule will probably fall by the wayside because of the ADA. Let's talk briefly about light duty positions. Light duty positions are opportunities for an employee to still work but not performing the core functions of their job, but only certain duties which they are capable due to their impairments to perform. Under the ADA, there's no obligation to create light duty positions for individuals with a disability as a reasonable accommodation. If it's available, then the employer can certainly consider that aspect, but it's not mandated by the ADA. Now, there may be a distinction with respect to certain workers' compensation rights, but under the ADA, light duty work is not mandated. It's not an obligation of the employer to provide. Many employers will, however, provide light duty for good reasons and economic ones as a reasonable accommodation as well. So we've now concluded this week's discussion of disability-related claims under the ADA, the Rehabilitation Act, and to some extent the workers' compensation laws. It's a lot of material. Please examine carefully the course handouts. A lot of this information is contained within the course supplemental handouts, as well as, of course, looking at Professor Twomey's textbook materials. Thank you.